The content of this webinar is not legal advice. The decisions you make regarding licensing should be guided by your lawyer and will be affected by the law in your country. Well, a second key question for license agreements is, will the licensor or licensee be responsible for mass manufacturing? Manufacturing is normally a large investment expense and headache for whoever handles it. In most instances, it's preferable to get the licensee to handle the manufacture of the product. However, it's a matter of negotiation, and the viability of this approach varies from agreement to agreement. Sometimes the licensor will establish a pilot plant to demonstrate manufacturability of the product, but then later transfer this know-how under the terms of the license to the licensee, and it is the licensee who will make the major investment in mass production. A third key question that your license agreement should normally address is, what is the geographical coverage of the license agreement? To maximise the value of IP, a licensor may choose to license their patent to different parties in different countries. A licensor may also grant licenses based on a degree of geographical segmentation of the manufacturing and/or sales territory. For example, a licensee might pay a royalty rate of 5% of sales in Australia and another royalty rate of 6% of sales in New Zealand. Manufacturing-based royalty rates can also be geographically segmented. By doing this, a licensor can derive multiple sets of incomes from a single license agreement. Well, a fourth key question to be addressed is, what are the financial terms of the license? At the end of the day, most license negotiations come down to money. The financial terms can be arranged in numerous ways. For example, 1, an upfront license fee, or 2, a once-only or per-unit royalty based on product manufactured or sold, or 3, a combination of 1 and 2. Once again, each license agreement will differ significantly from the next, and there's no hard and fast rule that can be applied. Before entering into any license agreement, a lawyer with experience in IP issues should always be consulted. With all the aforementioned in mind, it is obvious that good patent protection is a vital precursor to successful licensing. Indeed, the purpose of the license agreement is to commercially exploit the monopoly rights inherent in the patent for a monetary return. In most instances, without a well-written patent, the licensor may not be seen to be bringing any value to the table at all. Only the very best patent specification and advice will put the licensor in a position to maximise profits from a licensing arrangement. If you're based in Australia and need advice about patent protection, please do give us a call. You can get our contact details from our website. Our URL is www.baxterip.com.au.